This week I learned about civil procedure in U.S. business law. Uh, my personal takeaways is that I was not familiar with the U.S. jury system, uh, but in in civil cases, I realized that jury uh, uh, play a important role in the court procedure. However, judges have more discretion in civil cases than criminal cases to override or modify a jury's decision if there are errors. There are two areas of jurisdiction. One is personal jurisdiction. Generally, a court has personal jurisdiction over those that reside within the court's geographic boundaries. The court can exercise personal jurisdiction over business in three places where the business is headquartered, the state where it is incorporated or registered, and any state where it conducts substantial business. Other jurisdiction is federal court subject matter. A case can be heard in federal court when it involves a federal question or meet the diversity of citizenship requirement. Federal question cases require an interpretation of the U.S. Constitution, a federal status, or a federal treaty. Venue determines which trial court will hear the case. The trial court in the county where the defendant resides is the appropriate venue. There's steps in civil litigation. First is pleadings. The first document filed with the courts are known as pleadings. The plaintiff's complaint and followed by the defendant answer. If the defendant fails to respond, the judge may grant a default judgment, awarding the plaintiff everything he or she requested. There is a discovery procedure. In this process, each side tries to get as much information as possible from the other party. Both the plaintiff and defendant are required to give information to the other side and thus eliminating the once common game of trying to surprise the other side in trial. There is a pre-trial conference which clarify issues and set a timetable for discovery and the subsequent trial. At trial, the first order of business is to select a jury. After the jury is selected and seated, the plaintiff's lawyer begins with an opening statement and laying out the nature of the case and the facts are seen by the plaintiffs. And evidence will be submitted. The defendant attorney will likewise make an opening statement, usually contradicting the opening statement made by the plaintiff lawyer. The plaintiff's attorney then calls witness, and the opposing lawyer may conduct cross examination. There is an appeal procedure. So the losing party may appeal when there is a significant error committed by the trial judge. There is alternative means of resolving disputes. Mostly disputes are settled with the parties negotiating some compromise to avoid the cost of litigation. There is arbitrator process. Arbitration is quicker and cheaper than civil litigation. And the rules and procedures are more relaxed than what is expected in court. And there is a mediation procedure. A mediator hears both sides' argument and attempts to help the parties come to a resolution. But mediator is a neutral party and have no power to impose a decision. This is the summary of the civil procedure I studied. Thank you very much for taking time.